we have another person coming in.
I guess just click continue if it asked you.
Yeah. So if everybody's ready and you would just please mute yourself if you're not muted already. I would like to thank our speakers coming today and educating us about financial planning and legacy planning. I'm Marcy Curtis from the Cleveland chapter of Na'amat, and I'd like to just take a moment and introduce our guest speakers. Lori Steiner received her JD magna cum laude from Cleveland State University, Cleveland Marshall College of Law. She has been named as a super lawyer for 2019, 20, and 21. Additionally, Ms. Steiner is a certified elder law attorney and is also an accredited attorney for the preparation, presentation, and prosecution of claims for veterans benefits before the Department of Veterans Affairs. Ms. Steiner focuses her practice on elder law, estate planning, disability, and probate. Sam Gervich, some of you may recognize his name, is the son of Jan Gervich, our president. Since 2001, Sam of the SDG Asset Management Group has been a financial advisor, helping families, charitable foundations, businesses, and nonprofits. Sam's firm is a registered investment advisor governed by the SEC and acts as a fiduciary for his clients, which means he is held to the highest standard in the industry. Sam is an active manager of stock portfolios and authors and implements financial plans addressing retirement and estate planning needs. With 20 years experience, Sam has helped families and organizations, including Na'amat USA, navigate through volatility, severe market crashes, and recessions to help them safely achieve their goals. And now I'd like to turn the program over to Sam and Lori. And they have a PowerPoint presentation they're going to share with us. At the end of our program, if you put your questions in the chat area, we'll be sure and ask any questions that you have. Sam and Lori, I'll turn it over to you.
Thank you, Marcy. It's great to be back doing this. We had done this a year ago, and this time we have an estate planning attorney, which is really going to be helpful, especially when we talk about some of the sophisticated ways to maximize resources. It's especially gratifying for me to do these workshops because my family's been 5 generations involved with the organization, including great-grandmothers, grandmothers, my mother, my wife, and my daughter. So this presentation is not going to be an estate planning 101, and it's not going to be overly detailed. It's going to give you some hopefully exciting ideas for maximizing your resources, getting the most out of them, both for your loved ones and for causes that you believe in. Lori and I are each going to chime in at different points. We want to keep everyone engaged, and we are both looking very much forward to the Q&A because we always like when the audience can drive what we're talking about. So I'm going to share our screen. Okay. So the title for today's event or workshop is Legacy Planning, Estate Planning That Feels Good. And that's Lori and I. And what this is really all about is finding a way to get the most out of your resources while taking care of your loved ones and the causes that you care about. You know, all of us want to take care of our loved ones, and some of us, especially those who are part of organizations like Na'amat, believe in tikkun olam, fixing a broken world, and we want to help you achieve your objective in doing that any way that we can. And we're going to talk today about how charitable giving can be part of an estate plan. You're here, that says something. You have a heartfelt concern and support for Na'amat and Israel. You've devoted countless volunteer hours You've made financial contributions over the years to the cause. We certainly need more people like you. And as you've been doing this, you've been building your legacy. And we understand if you showed up today or watching the recorded video, you'd like to learn more about estate planning and how to do the most with the resources that you have. So you worked hard for your money, accumulating assets, and there are strategies to help make that money work hard for you, further grow your assets, which gifting to the people you love, sometimes with a warm hand during your lifetime, sometimes after we leave this earth, and of course, devoting some of your assets to causes that you care about. Proper estate planning can help you get the most out of your assets, both during your lifetime and for the legacy that you leave behind.
Right. So Sam, thanks for that nice introduction to what we're going to be talking about today. So from an attorney's point of view, it takes a team, just like it takes a family or a country or neighborhood or other family members to raise your family. It takes a team even to handle estate planning and how to plan for the future and how to make sure that you're making the best choices. So estate planning is just that process. It's how to provide for yourself, your family, when you retire, if you become disabled, or especially when you die. So you put all of your legal and financial affairs in order so that the assets you've accumulated are preserved and they're transferred to your heirs or to any kind of legacy charitable organizations you might be interested in with the least amount of financial and emotional cost is the written way I say that, but it's the least amount of muss, fuss, and taxes mostly the time. So estate planning doesn't have to be just getting your things in order, getting your estate planning documents in place, making sure that you've thought about taxes and retirement and what if I get sick and end up in a nursing home. But you can also use estate planning as a way to make a charitable contribution before or after death that makes estate planning feel good. I mean, that's what it's all about, right? Having a good lifetime. So with proper planning, your estate planning can be legacy planning too. And we call it plan giving with benefits. So there are ways to make gifting work for you. There are things that you can do to reduce taxes, get more for you for your lifetime, and also leave more for your heirs and for any benefit, any charitable organizations you feel that you want to benefit. So we're going to talk about legacy planning to feel good by using a charitable plan gift during life or at death. And I've got some great statistics about charitable contributions. In 2020, even though that was a terrible year for most people with COVID and being locked down and everything, charitable contributions increased almost 30% this past year. And that allowed grants from these charitable organizations to be mostly for human services to increase by 37%. So people were really helping others during this past year, and that feels good. And it has, you can make that feeling continue.
So the overview, which we want to give you so you know where we're going with this and what ideas we're going to be talking about today. There are certainly simple ways to feel good, just giving some cash with a simple check to the charity of your choice. Other ways are to leverage IRAs and retirement accounts, leveraging required minimum distributions, even life insurance for pennies on the dollar. You can give a ton of money to both your loved ones and charities that you believe in, as well as securities like appreciated stock. And then there are more sophisticated strategies you can leverage, which Lori is certainly going to be talking about today. And we have some charts to help you keep some of the concepts organized that you can reference later, but we'll be talking about trusts like charitable remainder trusts, charitable lead trusts, and irrevocable charity and charitable annuity gifts. So again, this is all part of the theme of simple legacy planning to feel good. And it's not just for those who are wealthy. There are actually ways that people with lower means can make a big difference. And certainly an outright gift of cash or bequest is easy. And when you give cash to charity, certainly there can be tax deductions. And there are other ways where you could just name a charity in a will or a trust as a beneficiary, which can also satisfy your wishes. And there are methods to avoid probate or trust administration by naming a charity by POD or TOD or beneficiary designation. So another way is that's part of simply giving assets, and we're going to talk about a little bit more, we don't have to spend too much time on this slide, is there can be appreciated assets that if you were to liquidate them, they can have capital gains tax consequences. And again, we're all about trying to get the most out of our resources, stretching every dollar. Sometimes there can be advantages for making large gifts in certain years where you have a tax issue and you want to offset those taxes. So the bunching of gifts every other year might be wise. Other ways to free up resources for charitable giving: reduce expenses. That could be portfolio expenses. It could be reducing advisory fees. It's something that we're very passionate about. Too often we find portfolio expenses based on the fund or investment being used are creating drag on returns. Sometimes investment professionals charge what we feel is too much, and that can also create a drag on returns. And you can also reduce insurance premiums. Maybe there are insurance policies that you don't need anymore, or maybe you don't need as much coverage. Although we will talk about later ways that you can actually use existing life insurance policies that may have been created to achieve certain objectives years ago, but those objectives are no longer relevant. And you may decide to leave some of the money behind for charity of your choice. You can also free up resources by annuitizing annuities, which is a flow of income throughout your lifetime or for a fixed period of time. And you can also always explore with your accountant tax reducing strategies that you've not yet implemented, but those tax reducing strategies can be something that you collaborate with your estate planning attorney or even your financial advisor. Lori and I are not tax professionals, so we're not giving tax advice, but we are giving you some ideas that you can use in discussions with your accountant. Required minimum distributions, that's what RMDs are. And when we reach the age of 72, which is a relatively new rule, it used to be when you reach the age of 70 and a half, the government asks you to start making distributions from your retirement accounts, because years ago they allowed you to contribute to those retirement accounts, which reduced your adjustable or taxable income, and you did not pay income tax on that money you received and contributed to the retirement plan. So at some point they want you to start making distributions from the retirement accounts so they can start collecting income tax.
Right, and that's the main problem with those, right? You got to pay income tax as they come out. Mm-hmm. So what do we do?
So one way is to, if you do not need that income and making distributions is not coming at the right time for you, you may want to direct those RMDs to a charity of your choice. It benefits you and the cause you believe in. Now, how can it benefit you? When you make distributions from your retirement accounts, it increases your taxable income. When you do that, that can also push you into a higher tax bracket. And the tax rate that may be applied across other sources of income can actually increase your tax liability significantly. The tax rate may be higher prior to making distributions from your retirement accounts than afterwards. So to avoid distributions from your retirement account counting as additional income, you can direct your RMDs directly to a charity of your choice. So I have a lot of clients, especially at the end of the year, who decide they want to send money to their synagogue or other charities because they don't need the money. And by keeping themselves in a lower tax bracket, they would actually save perhaps even more money than what they're directing to the charity from their retirement accounts. So here's a slide that talks a little bit about the details. We're not going to go over all the details, but I would love it if Lori would chime in because she's an elder care specialist and she could talk about the impact on Medicare premiums.
Yeah, so, and that's part of the benefit of having somebody who, like, I'm an elder law specialist, which means I have to know all about all kinds of different areas. It's not just estate planning or wills or trust, but it's also health insurance like Medicare or Medicaid. And it's also retirement planning and housing and long-term care, and a lot of things. So one thing you got to be careful about though, if your income goes up, as we're talking about RMDs now, so if you've taken a required minimum distribution and that's 100% income taxable, it throws you into a higher tax bracket. A lot of people don't realize that that can cause your Medicare premium cost to go up. This year is $148.50 for most people, but if you're in a higher tax bracket, that amount is more on a monthly basis. So that can have an impact not only on your taxes, but also on your Medicare premium, which most folks like to keep low. So, you know, there's unknown sometimes for people other tax consequences and other benefit consequences that can be helped by getting that income tax out of your earnings for that year.
Now, the age at which you are required to start making distributions is no longer it's now age 72. So just be mindful of that change. And again, this strategy is a way to address unwanted tax liabilities. And it's a great example of how you can get the most out of your resources and stretch every dollar. Well, someone might say, well, what if I'm not 72 yet?
You can still take out distributions, right?
Yeah.
You have to start taking them at 72, but you can take them anytime after 59 and a half without any penalty. So it's one of the planning tips as you age. Do you really need to take the distributions before you have to start, for sure? But, you know, it's those kinds of things that you need your team to be looking at.
Mm-hmm. And also, you know, we talk about gifting during our lifetime. Sometimes we like to give with a warm hand, but you can also simply update your beneficiaries on retirement accounts such that they align with your goals and the causes that you believe in and the charitable contributions you'd like to make. So you may want to make sure that you have a certain amount of resources during your lifetime. And then afterwards, as part of your legacy, having some assets directed towards the charities that you believe in. Life insurance. So there are multiple ways that you can benefit or leverage life insurance to help your loved ones and at the same time satisfy charitable gifting objectives. You can designate your charity as a beneficiary. Now, what happens if you know, the mortgage is paid up, kids have gone through school, there were no student loans, or your kids are handling the student loans. At the same time, you still want to leave something for your children and your grandchildren. You don't have to leave 100% of a life insurance policy to a charity in order for the charity to benefit. You can designate only 5% of the death benefit to go to the charity of your choice. Again, this and all other strategies should fit as part of a complete estate plan. So you don't want to look at any one of these strategies in a silo, but you want all your ships to sail in the same direction. So you want a well-coordinated estate plan, and leveraging a life insurance policy can be useful. You can designate the charity and your loved ones as beneficiaries. You can also make the charity the owner of your policy, and you might be able to get a tax deduction for the premiums that you pay. Premiums are typically, they cost pennies on the dollar, meaning you spend a lot less having the life insurance policy than the money that the life insurance policy gives to your beneficiaries. So it's an inexpensive way to give to your loved ones and to the charities that you believe in. And
it's also a good way. Yeah, you can get a term policy, have the charity own it. You make the term insurance policy premiums, and that takes those premiums and gives you a tax deduction, takes the ownership of your policy out of your name. There's actually some types of plans you can do that life insurance policy that's owned by the charity that you're making the payments on, they're able to leverage that to help them during your lifetime. And then it takes the value of that policy. If you had held it until your death and then left it to a family member or to a charity, there's potential for estate taxes on that. Right. So there's a way that you can get those estate taxes out of your assets or reduce your assets to the point where you don't have any estate taxes by not owning that policy. Right. So there's all kinds of tricks and tips having to do with life insurance.
So making the charity the owner of the insurance policy would help accomplish that. So, or one of those objectives, which, you know, where the death benefit or the cash left behind may not be taxed. You can also leverage any cash value that's in the insurance policy. If you borrow only a certain amount from the policy such that the policy will stay in force and remain funded, you can actually take money out of the life insurance policy as a loan that you're not required to pay back. It just reduces the death benefit after you're gone, but you can actually then give more money during your lifetime with a warm hand to the charity of your choice or to a loved one. And another slide that talks a little bit about what we were just covering. A little bit more. You may also have stocks that have appreciated quite a bit. And I often come across clients who tell me that they're concerned about liquidating a certain holding because of the potential capital gains tax. It could be significant. But let's say you're charitably inclined to give to a cause and you have such an issue. You want to liquidate or are considering liquidating a stock holding, but you're concerned about the capital gains tax. You can simply transfer ownership of the appreciated stock or bond to a charity. You would receive a donation receipt and you can get a tax deduction. Based on the value of the security on the date it was transferred, you will have that tax deduction is something, of course, you want to discuss with your accountant, but typically whatever the value was of the stock on the day you transfer it is typically going to be what the tax deduction will be based on. And that solves a big tax problem for a lot of people. So again, we're talking about ways to help make the most out of your financial resources, stretching your assets to achieve multiple objectives. And now we're going to start talking about trusts. It's a bit of a more sophisticated strategy to implement, but it doesn't have to be overly complicated. And if you have a great professional specialist to help you with your trusts and estates, then it's not going to be as difficult a task as one might think. So with that, I want to let Lori speak about trusts.
So I get lots of blank faces when I'm in a meeting with a client or a family and we're talking about estate planning and what's involved, and part of estate planning is avoiding taxes. And we've talked even a little bit about avoiding income taxes and estate taxes already. But another big thing is how to avoid probate. People don't want to have to go through probate. It's been known out there that it's expensive. It takes a long time. There's a lot of paperwork involved. So one of the ways that you can avoid probate is by setting up a trust. And if your assets are in the trust or pay to your trust when you die, then that avoids probate. So that's one good thing. But people are afraid, well, I don't have enough money to have a trust. I'm not sophisticated enough to have a trust. Well, that's not necessarily so. I have to explain to people what a trust is. People are afraid of it. They don't understand. They think that somebody else owns the money or the bank owns the money. So a trust is simply a relationship. It's a contractual relationship. And there's three parties to that relationship. The first party is called the settlor or the grantor or the trustor. Those are kind of interchangeable words, and you'll see different words in different kinds of trusts. And that's a person who sets it up. Usually it's you with your money. The next party to the trust is called the trustee. That's the person who actually is in charge of investing those assets, holding on to them, keeping them safe, making distributions as necessary, and investing everything. So the trustee, if it's your trust you're setting up, you're the settlor, you set it up, and you're also typically the trustee. Not in every situation with a trust, but in many normal revocable living trust situations, you're also the trustee. So it's just, instead of an asset being in your individual name, it's in your name as trustee of the trust. And it's still your social security number. Everything runs pretty much the same as if you owned it. The third party to a trust is called the beneficiary. Could be just one, it could be many, it could be a charitable beneficiary. So the beneficiary is, who is that money being held for? If you're setting up this contract to have somebody watch the money, it has to be for someone. And typically while you're alive and you're working with this trust, you're setting it up, you're the trustee in charge of it, and you're the beneficiary. You as the settlor never change. The trustee can change as you are unable to do it, or if you've passed away, somebody else becomes the trustee, and the beneficiary can change too, from you to your spouse, to your children, to charity, however you want to set that up. So what can a trust do? A trust can serve as a way to save estate taxes. If you're subject to estate taxes, then this is a way to reduce the cost of those estate taxes when you die. You can hold assets in a trust until you think it's the right time or right way to distribute them. We oftentimes do something called a bloodline trust. A bloodline trust means that you set up the trust, you and your husband, if you're married, or you and your wife, if you're married, can set up a trust. The trust money is for you guys while you're alive. And when you die, you have the trust split into equal shares for your children. And then it can stay in that trust. The children can use it for their living expenses, but it stays in the trust. And by setting it up right, you can protect your children from their creditors. For example, maybe you've got somebody who is in a risky business or is prone to lawsuits, like doctors who are prone to medical malpractice lawsuits. You can set up a trust that protects that money you've left for your family member for the rest of their life from those kind of creditors. Or if you've got a worry about the stability of a family, or you're worried that your son or your daughter is married to somebody, if you leave the money outright to them, they could put their spouse's name on it. And then if your child dies, now the money is in the name of their ex-spouse, who may remarry, and the money may end up going out of your bloodline. So it can prevent from that, or prevent from divorces being able to touch money that you want to leave for your child and then for your grandchildren. That's probably that's the most used way that we have a trust set up, is this bloodline trust. You can use it simply for financial management of your assets. You're not able to handle things anymore. A fiduciary, a trustee comes in and they have to take care of that money for your benefit. It can avoid probate, as I earlier said, and you can also establish certain kinds of trusts to fund a charitable gift. That's where it gets a little bit more complicated, a little bit more sophisticated in planning than we usually are talking about a trust. But a trust can do so many things. We set up revocable trust for most of this kind of thing while you're alive. It's typically, the trust is established by setting it up, signing the paperwork. It might be 20 pages long or 40 pages long. It's just a contractual agreement. It's very private. The court doesn't get involved in that. The settlor during lifetime can make changes to the trust anytime to change a distribution change of mind as how everything should go. Assets can be put in the trust while you're alive. Assets can be put in the trust only when you pass away. So it's really, but it's not a do-it-yourself kind of thing. I would encourage you to seek help from an estate planning attorney to set up a trust agreement. Even a will, if you do things wrong, it really makes a mess for your family after you pass away. So be sure and get some help in setting up even what you conceive of as a simple trust. There's a lot of tax considerations. There's a lot of personal considerations that have to go into the decision making and how it's all going to be set up. So you got to be kind of careful. But while you're alive, usually the trust is revocable. When you die, it becomes irrevocable. So nobody else, some new trustee that's taking things over, can't make changes to how you want your assets to pass. Other trusts have to be irrevocable from the beginning. Some trusts, we do special needs trusts for disabled beneficiaries, either children or others. And those have to be irrevocable to follow the statutory rules to allow that money to be held there for them without interfering with their benefits, their government benefits that they might have. There are also certain types of trusts for charitable purposes that have to be irrevocable from the get-go. So this is a long explanation of what is called an irrevocable charitable remainder trust. I'm going to just give you the main points. What does that mean? What is this for? So it's an actual trust agreement. And typically, again, you want a charitable foundation to help you set this up or an attorney to help you set this up because it has to be just so. It's an actual trust agreement that you put money into. Because it's called a charitable remainder trust, that means the charity gets what's remaining in it at the end of a term of years, you say 20 years, or at the end of your lifetime when you die. There is a couple different kinds of charitable remainder trusts. You might hear about a charitable remainder annuity trust or a charitable remainder unit trust. So it can be a CRAT or a CRUT in our terms. We throw those terms around. Go back, I'm not quite done with the, yeah, there we go. So how that works is you put money in and then you get a stream of income for the rest of your life. Each different kind of trust has a different way of calculating that income, but you get a percentage of that income for lifetime. It could be fixed, it could be variable, depending on the type of trust you set up. But so you can live off of that money. It's helpful for you, but when you die, then the charity gets whatever is left in there. So that's why it's a charitable remainder trust. And just as an idea, there's no special number of amount of money that you have to put into it, but around 100,000 or more is probably common for this kind of trust. But it just depends upon the family and the situation and the charity. All right, so then there's kind of the opposite thing, which is called a charitable lead trust, which kind of sounds, it kind of is named what it sounds like. It's a little bit like an opposite of a charitable remainder trust. And in this case, you put an asset into it that can be invested and the charity gets the income while you're alive. So it can be for a lifetime, it can be for a period of time, but they're using that money while you are living. And then at the end of the term or when you pass away, then the bulk of money that's left in there after the charity has been using it for many years can pass to either the charity or it can pass to a beneficiary of your choice. One example of how some people use this is that they want to, they've got maybe limited assets or they've got an idea in mind. They want each of their children to receive $1 million or each of their children to receive $500,000, whatever it is. And they don't know if they're going to be using up their regular assets during lifetime or not. If they get sick and go to a nursing home, they might be depleting assets. And what they own can impact their ability to qualify for government benefits like Medicaid in order to pay for those that care need, especially in a nursing home. I mean, the average cost of the nursing homes in Ohio is $7,000 and up per month. So it's not a cheap thing. So this is a way that they can set up money that the charity owns. They're using the earnings from that money. It doesn't cause an inclusion in their assets for purposes of Medicaid eligibility. But yet they are getting some living expenses that they can pay from the trust. And then at the end, when they pass away, even if they've spent all of their money trying to pay for long-term care or the nursing home, or they're getting rid of it from Medicaid, the charitable, that pot of money now, the charity is done with it, and it can pay a fixed amount at this point, what's left over, to make sure that those children still get some type of an inheritance. So that is often how that type of trust is used. It's blending your needs during lifetime and taxes and benefits with still providing something to help your children and to leave for them at death. A lot of times, this is a little bit more sophisticated, so you might need a lot more money to invest in this to make it worthwhile for the charity and for leaving something to your children. But it's one of those ways that you can use. Next is kind of a twist on both of those. This is more of an actual annuity that is purchased. So it's very popular. You don't need a whole lot of money to do this. You can set up a charitable gift annuity with $10,000, more or less, whatever you would like. So what that does is you buy an annuity, and what annuity is just a contract saying, I'm going to put this money into this contract and it's gone. You know, I'm not going to be able to get that money back, but I will be able to get monthly or annual checks on that. That's the return. That's what the annuity is from. The underlying money stays in there. The income comes out of it over your lifetime. It could be over a husband and wife's lifetime. And then when you die, so you're living off of that money. And when you die, what's remaining in that annuity then goes to the charity. So you can get tax benefits with all of these various trusts and annuities. You can get tax benefits now by income tax deductions. You can get tax benefits at your death by avoiding estate taxes. And it's another way to take money that maybe you're not using on a daily basis and make this annuity set up so that you can live off of it. But when you die, or at the term end of the second or third life, or whatever it is, that the charity gets it. So it's just another tool in the arsenal that we have for how to pass money on and help our family and help charity at the same time. The rest of the next 3 or 4 slides that are in here are charts that, when you get to have a copy of it, they are simply kind of making charts that you can compare the different types of charitable gifts and see what might be right for you. It's a quickie reminder of what everything is sort of about, because we've talked about some important things, and I know it's hard to remember everything. So we try to put that together so you can kind of look at that and see the differences and what we've been talking about here so far.
And again, these are not all the ideas that exist out there. There are many different ways to accomplish all of your objectives. Of course, if there are opportunities to accomplish multiple objectives simultaneously with the same strategy, that's very efficient and that's wonderful. But each person has their own unique story. They have their own set of circumstances, their own set of resources, cash flow, personalities, preferences. So you just want to have collaborative conversations with your financial professionals, whether it's an accountant, an estate planning attorney, your investment or financial advisor. Ideally to get them all in the same room, whether that's a physical room or a virtual room, but get them all on the same page and collaborate with each other. And there's no one size fits all. There can be a lot of tools in the toolbox. I always say we just try to bring the right tools to the specific job, but you each have your own unique story, situation, and preferences. And that's what should drive the strategies that you consider and then later implement.
And if you're meeting with one of your professionals and they don't bring it up and you have questions or you want to think about it, I mean, ask those questions. It's important to ask.
Yeah.
Maybe it'll be right for you, maybe it won't, but in any event, you need to investigate all kinds of things when you're setting up your estate plan.
Right. You know, you guys are the driver of the car, and your advisors should be the GPS on a dashboard. You know, when we're managing money, there are two things at risk, you know, the person's money and our reputation. But ultimately, the client is the driver. It's their assets, okay? The advisors should be giving you advice or making suggestions that fit what you want to see happen. So we may come up with a wonderful plan, or your professional or consultant may come up with a wonderful plan. Technically, it's up to you. It's your prerogative. If the GPS tells you to turn right at the next light, but you want to take a detour, that's your prerogative. And then it's on the shoulders. It's the burden of your consultants to pivot and adjust and recalculate the more efficient route based on the change that you made.
That's exactly right. I represent people, and I represent what you want, and whatever in the end that you decide is what I have to do. So don't ever be afraid to ask any questions. I see that we have some questions in the chat, and we're welcoming those in the minutes that follow before we're all done with our presentation, because you need to ask those questions and make sure that what is being done is right for you.
We do have some questions.
Okay.
And so I didn't know whether you wanted to stop sharing your screen so we could see your faces as you answer them, or if you want to leave that on the screen.
Okay. Well, we're gonna wrap up and then go to the Q&A, and I'll stop sharing the screen at that point.
Okay.
So this is, you know, the theme of today is your legacy. There's one thing we take with us when we leave this world, and it lives on forever. It's our good name, our legacy, and there are things we can leave behind that can make an impact on the lives of the people we care about and the world they live in after us. So again, it's your story. You're the author of your own story, your own legacy. Your story is still being written by you. Of course, you may wonder what your next chapter looks like. Consult with your advisors. Planned legacy giving can be a wonderful thing, especially when done efficiently, because it gets the most out of your resources to support the charities you believe in. It feels good. It makes the world a better place, furthers your legacy, stretches your resources, and helps your loved ones. So giving can be done in a smart and efficient way that maximizes those resources, stretches every dollar to achieve as many of your objectives as possible. But any giving feels good. So with that, let's roll with any questions that came in on the chat, and I'll stop sharing the screen. FYI, just for the video, here's contact info if you have any follow-up questions that we can't get to today. We're happy to answer them.
All right. So the first question was, if a charity is the owner of a life insurance policy, how does the charity ensure that the premiums are paid?
Well, part of that is trust. I mean, you're going to be entering into this arrangement with the person who, you know, wants to make this plan work. So you got to hope that they're going to continue to make those premium payments. Of course, if the premium payments aren't made, if it's a term policy, it'll just disappear. So it's a loss for everybody in that case. So they've got to want to do that. You can't force them to do that. But if they're anxious if that plan makes sense to the person and that's what they're trying to do, I mean, hopefully they're going to make those premium payments. It's a good question. It's a worry for the charities.
What I love about the question.
My question, may I just follow up with another comment about it? I'm in Canada, and I know our rules are slightly different, but my concern as the person who signs charitable donation receipts is that we have taken on this obligation with an insurance policy. If the person changes the beneficiary, we have issued receipts in the name of this individual because supposedly we were being given a donation, but we are getting nothing now. So how does one encourage the person wanting to leave their legacy to actually leave it in a way that the charity will get it? I guess that's my question. How do you encourage a person to actually make this legacy happen and not change their mind?
Normally, the insurance policy can be owned by the charity, and the person's just making the premium payments. So the receipt every year is for the premium payment being made, not for this entire amount of the policy or something like that.
That I understand, but we have to be sure that this person is still going to want to make the premium payments too, or we have nothing.
Potentially, yes. So
Yeah.
You got any advice?
So my understanding is correct.
What I love about the question is very often, sometimes people think the financial advisor, if it's finance related, they can do everything finance related for me. But again, it involves leveraging all the different professionals that you have in your arsenal. And while we help essentially fund strategies for clients, we certainly rely on the attorneys to draft the legal documents. So if someone is giving ownership over to the charity of their choice, they may want to have a legal contract put in place, presuming it's legal, and have the attorney draft one up. So the rules of engagement are established before the gift is made.
Yeah. Or it's set up as a trust rather than simply a life insurance policy. There's other, there's different ways to structure things so that it becomes a little bit more, I think, permanent, I guess, for the charitable organization, expecting and relying on that gift.
Right. So giving up control can often be scary. So if there's a way to make sure that the rule or the understanding is followed, then a legal contract can be drawn up. But the caveat is, like with any other contract, one side can always breach the contract, and then you have a lawsuit. And yes, that's a headache, but you have to make that decision. It can be a calculated risk, but also, again, not all of these strategies are applicable to everyone. And you want to take into account the dynamic of the relationship, the personalities involved. There's so many different scenarios we could go into, but it doesn't pay. The bottom line is what feels right for that situation. It's something to talk through when you're considering a specific strategy.
Okay, the next question is, can an IRA be included in your trust?
Ooh, that's an interesting question. IRAs are owned by you. The only way an IRA is if you own it and it's your IRA, or it's a rollover from somebody else, because the ownership of an IRA can never be in a trust. A trust can be a beneficiary of an IRA, but there's all kinds of rules that go along with that, which we don't have time to get into because it's very individual. But if you're leaving IRAs to a trust, there has to be specific language in the trust. If you're leaving it to a person, there are rules that determine how long that IRA payment can, after when they start getting it, how long it can go out. The Secure Act, which went into effect, I think, January of 2020, changed some of those rules. So there are very specific rules. An IRA cannot be owned by a trust, but a trust might be able to be the beneficiary, but there's all kinds of rules you got to look at.
Lori, do you want to talk a little bit about the value of leaving an IRA to a trust versus just naming the different beneficiaries on the IRA account?
Well, there are the Secure Act, as I mentioned, changed the rule. Let's say you've got husband and wife and they leave their IRAs to each other, and now the money at the second death is going to go on to a child. Mm-hmm. It used to be the child could take it out, those required minimum distributions over lifetime, but they've changed that now. They've changed that to be over a 10-year period. Apparently the government wants more money being cashed out faster to get a little bit more income into the federal government. So they've changed that. That changes some of the planning tools that we use. It used to be you could set up a special kind of trust to be the beneficiary of an IRA, and then it could, we call it a stretch IRA, and those IRAs could pay out over the lifetime of that child and cause not a whole lot of bad tax consequences, because little bit was coming out every year over many years. But now the tax consequences of a stretch IRA are completely different, because it has to pay out over 10 years. So, and that's one reason now I think there's a way to leverage your IRA distributions to a charity. And you can give up to a certain amount during a year, and then you don't have to pay income taxes on it. And you can leave the beneficiary to be a charity, and nobody has to pay those income tax consequences.
Another thing is sometimes, depending on what type of trust you're setting up, it can be beneficial to name a trust as a beneficiary, because you may have multiple retirement accounts, and to update all your accounts anytime there's a change you want to make to your beneficiaries can really be a pain in the neck. So if you have one trust document to update, that'll also simplify your life.
But it's got to have the right language for any particular IRA. That's where the attorneys come in.
Any other questions?
Yes. The next question is, I've been told I cannot park my RMDs in a community foundation. Where can it be parked?
Well, you can send your RMDs directly to a synagogue. You can send it directly to an organization. So, Na'amat is one of them, Hadassah, one of the environmental nonprofit organizations, maybe one that's pursuing medical research to find a cure. Direct them to the specific cause that you believe in, rather than a foundation that may be giving to certain causes that you don't particularly have strong feelings about.
Yeah, and we specifically didn't talk about foundations and private, donor advised funds and some of the more sophisticated things, because we're trying to focus on personal estate planning and families and what people can do. Very good.
And by the way, so we're multi-custodial, so we can work with Pershing, Fidelity, Charles Schwab. Charles Schwab has been wonderful. So they're our primary clearinghouse, and they actually have a wonderful program for charitable foundations and donor funds. But maybe that's something we can talk about in a subsequent workshop.
How often should you update your trust?
As often as necessary. So when we're working with clients, we try to make sure they have all of their important estate planning documents in place: will, financial power of attorney, healthcare power of attorney, living will, and a trust if it's important. And we actually send out letters to our clients every 3 years saying, hey, things could have changed. Health, wealth, birth, death, marriage, divorce, all of those kinds of things can mean a change to your trust or to your estate planning documents. So they're not static. It's not one and done. It is definitely something you need to update as your personal circumstances or wishes change.
Okay, that brings us to the next question, kind of. If there's an estrangement of sorts of a parent or child relation, and one out of several children is not included in a will or trust, can anything be done for the child that is excluded?
I'm not sure what the question means is, can anything be done? If there is a necessity to exclude a child for whatever reason,
maybe they mean in terms of avoiding a contested.
Maybe that's it. There's a provision you can put in a will or a trust that says if anybody contests this document, then they get nothing anyway if you're trying to keep them out. That doesn't always stop a disinherited child from suing. Even though that provision says if you sue, you get nothing, people still sue.
What if they leave?
It's a difficult issue.
What if they leave like a small amount of money, maybe $1 or $100 or something like that?
A lot of people think that's what you have to leave something, but I had that backfire. I had a client whose dad wanted to leave nothing to one of his sons, and his daughter said, at least leave him something, give him $15,000 so he feels like he got something. He's still suing the trust in order to try to get a bigger share. So, you don't need to do that. It's unnecessary. And it could backfire anyway, thinking, if there's that much, I can get more,
Well, and the last thing that I see is actually a comment to remind people that monies from the RMD can be taken out periodically as needed for the same organization over the course of the year.
Mm-hmm. Yeah, I think traditionally people get their RMDs in one lump sum, like in December or something like that, but you can choose to take it any way or choose it to be distributed in any way.
Sometimes people don't want to do the accounting and keep track of how much did I take out so far. I get calls about that. How much did we take out so far? So sometimes in the end, they end up in subsequent years just directing the full amount or making the distribution for the full amount just to avoid that extra work.
Should a person let the charity know that they are naming them in a will or other document?
When I'm putting a distribution like that in a will or a trust, I encourage them to let them know. It's not necessarily my place unless they ask me to. But I think the charity would like to know, and so they can plan for that. The problem is if it's not an irrevocable type of designation, it can change at any time. Mm-hmm. So, people have the right to do that.
And it might feel good to tell the charity, while you're alive, hey, I'm making this request.
And then let's finish it up with this one question. What are the most important estate planning documents everyone should have?
That's an excellent question. And I mentioned them earlier, but I call them my core four: a last will and testament, a financial power of attorney, a healthcare power of attorney, and a living will. So all of those serve different purposes and everybody should have that. And then I say, if that's the core four, the thumb is a trust agreement if necessary. Some people need it, some people don't. There's all different reasons why you might need it or not need it. And that's the kind of thing you need to talk over with your legal and financial and tax professionals.
And a very big recommendation I feel very strongly about is before you go to the estate planning attorney, have all of your statements and accounts together. And if possible, ask your financial advisor. We provide these websites that are customized for each client where they can log in and see all of their accounts, their bank accounts, even credit card accounts, insurance policies, investment brokerage accounts. And it shows cash flow. It includes a financial plan. And when you go into your estate planning attorney's office with that kind of a tool, right away, they could see all your assets, all your liabilities. They could see things that are going on, and it'll set off red flags and ideas for them to bring up in conversation during their discovery process.
Exactly. The more information, the better to come up with the best possible plan. And that's why I always say it's a team effort. It's the estate planning attorney, and it's the financial person, and it's the tax person, and it's the family, and it's, everybody is involved in trying to make sure this thing is the right thing for any individual person.
Someone also asked a question, is there a good book that explains all of this? Can you recommend any kind of a book?
That's
a tough one.
Good question. It's hard to, I haven't read every book out there on estate planning. It's hard to do that. I try to, when clients ask questions, I try to have handouts that I can say, oh, here's some more information about trust, or here's some more information about powers of attorney, so that I know what they're looking at, as opposed to saying, yeah, there was some woman, what's the woman's name that wrote this book about trust and everything? Everyone comes in saying, well, she said I have to do this. Well, what makes her the expert?
Yeah, there are more than one way to do things. And just because someone authors a book doesn't make them an expert. They're just offering their perspective, their ideas. But again, everyone's situation is different. So it's kind of dangerous. Like, the uneducated voter, you may only receive perspective.
Looks like Sam froze up.
I'll come back.
And can you hear me?
We can hear you now.
Okay. So if you want afterwards, follow up with us, and we'll try to think of some books that might be worthwhile to to send out.
Yeah, and I mostly have people I know in the community, people who know about Medicare choices and people who know about how to find the best assisted living, or people who know about, Social Security and choosing the best plan for that, things like that. I'd rather refer you to somebody I know knows what it is than some book that I haven't read yet.
Mm-hmm. Can I ask a question? Do different states have different laws or rules, or is it a countrywide thing?
For estate planning, from my point of view, it's really state specific. I am licensed in Ohio and I can do Ohio work. I can't draft a deed in Florida. We have people in Florida that we call for that. So for legal world, it is very state specific. Even though there's federal laws, there's most of the time state laws that you have to worry about as well. And you can't really practice in a state you're not licensed in and keep up with. But Sam, I think you're a little different.
Yeah, so we're actually registered. We're governed by the SEC, so we work for clients in all 50 states. But there are certain rules that that vary between states, like with certain types of financial products. So we just have to be aware of them. However, an estate planning attorney, regardless of what state they're involved in, if they're any good, they should be able to give you a good idea of strategies available to you. And people like Lori are networked with attorneys in other states. So let's say, you know Lori, you like the way she presents, you can tell she's knowledgeable, and you're looking for a recommendation, she can make an introduction to an estate planning attorney in another state. And, she might know multiple estate planning attorneys, just like I know many accountants. And I look at the client and their situation, and based on what I know about them, that will help me pair them with the professional that I think will work best for them.
That's the same thing. I mean, I know a little bit more about Florida than other states because we have snowbirds that spend part of the year in Ohio and part in Florida, but that doesn't mean I could draft a trust that is under Florida law. I just am not licensed to do that, but I know a lot of people in Florida who can.
Well, Sam and Lori, I want to thank you very much for giving us your time today, your knowledge. I know that many people have commented how much they learned today. So on behalf of everyone that attended, I want to thank you very much. There is going to be a video of this. It was recorded. And so, Deanna, do you want to talk about that for a minute?
Sure. I'll just, I'm going to upload it to our YouTube channel, and I'll send out the link for everyone that has attended today. And if by chance you don't see it or have any kind of a problem, you can always contact me. So happy to get it.
And just for compliance purposes, no advice has been given during this presentation. We have not given any kind of tax advice or recommendations for specific actions. We just have to do that disclaimer.
Yeah, and it's not so much I have to say it, but it's also true. There is no attorney-client privilege that has been set up by this presentation. That means if you want information, you and I have to talk together, and then we have a client-attorney relationship, and then I can't tell anybody else about your stuff.
Well, thank you very much.